So, in our second part, relating to the second lecture on representation of the people, Act 1951, we would like to discuss certain 8 important landmark judgments delivered by the apex court or the high courts in India. So, the first one that we would like to discuss is relating to Union of India versus Association for Democratic Reforms, which was decided in 2002. So, the very judgment delivered in this important landmark case, the Supreme Court mandated that candidates must disclose their criminal records, assets, liabilities, and educational qualifications when filing nominations, and the very impact it left enhanced transparency and voter awareness, laying groundwork for voters' right to know as a fundamental right falling under Article 19, Clause 1, Subclause A, and the next second most important landmark judgment relating to is Kuldeep Nair versus Union of India in the year 2006, where exactly the Supreme Court laid down that to uphold constitutional validity of open ballot voting in Rajya Sabha elections aimed at reducing cross voting and corruption. And the third important leading case or landmark judgment relating to the act is Navjot Singh Sidhu versus State of Punjab, which was decided in the year 2007, where the very judgment addressed disqualification under Section 8 following criminal conviction, clarifying that such disqualification applies immediately upon conviction. And the next most important landmark ruling, a judgment delivered by the apex court, is relating to Lily Thomas versus Union of India in 2013. So, in that particular landmark case, Supreme Court held that any MP, MLA or MLC convicted of an offence and sentenced to 2 years or more shall be disqualified immediately without benefit of appeal. And the very impact of this judgment overturned Section 8 subsection 4, which was amended accordingly, which previously was allowing convicted lawmakers to continue in office while appealing. And the next important landmark judgment is Rajwala versus State of Haryana, and that was decided in the year 2015. So, where the Supreme Court upheld Haryana's law imposing educational qualifications as a criterion to contest panchayat elections. So the very judgment left its impact and raised debates on whether educational qualifications should be mandatory for electoral candidates at all levels. Then the next important judgment relates to Krishna Kumar Singh versus State of Bihar, decided in 2017, which in particularly where Supreme Court ruled on the limitation of ordinances issued without legislative approval, impacting election-related ordinances issued by states, and the very impact of this decision strengthened the principle that electoral laws must undergo proper legislative scrutiny. And another important judgment delivered in the year 2017, that is Anurag Narayan Singh versus Harshvardhan Bajpayee, and in particularly this is a decision delivered by the Allahabad High Court, show the very background of the case. It was challenged against the 2017 Allahabad High Court ruling. Allegation of corrupt practices under Section 123, subsection 2, which is defining undue influence, and Section 123, subsection 4, which define what is false statement in the very electoral process of by a candidate who stand for any elections, and the very accused MLC's alleged offences regarding non-disclosure of liabilities and false information about educational qualifications. And the Allahabad High Court's decision, which dismissed the petition, stating that inaccuracies in affidavit were not substantial enough to influence election results or voters' decision. The facts were not deemed to be significant character to be classified as corrupt practices. And another important judgment that was delivered in the year 2018, that is Public Interest Foundation, Union of India. So, in that particular judgment, the Supreme Court declined to bar individuals with criminal charges from contesting elections, but directed political parties to publicize criminal background of candidates. And the very impact of the judgment led to the Election Commission of India to issue guidelines requiring candidates and parties to publish details of criminal cases in newspapers and on social media. So, now we would like to discuss the very conclusion, and the very conclusion it relates to the electoral bond scheme, the Election Laws Amendment Act 2021, the Election Commission of India's 2020 guidelines, and Supreme Court's 2023 ruling, and the aspect relating to one nation, one election. So, the very conclusion that relates to all such important aspects. So, in particularly, electoral bond scheme, which was challenged in Supreme Court in the year 2024, as the controversy is regarding allegations of opacity in political funding via anonymous donors, and at present the very status is matter is sub judice before the Supreme Court, with significant implications for transparency in campaign financing. And the Election Laws Amendment Act 2021 made significant changes, allows linking of voter ID with Aadhaar to prevent duplicate voter entries. So it concerns raises issues around privacy and potential for voter disenfranchisement. Then the criminalization of politics, which is an ongoing issue. Despite Supreme Court directives, significant percentage of MPs and MLAs have pending criminal cases. So the 2020 Election Commission of India guidelines mandated political parties to explain why candidates with criminal backgrounds were chosen over clean candidates. Finally, in 2023, the Supreme Court ruling which directed political parties to publicly disclose criminal antecedents of candidates within 48 hours of selection, and due to its impact, aimed to curb increasing trend of criminalization in politics and further. Another improvement or development made regarding one nation, one election proposal. The very proposal to synchronize Lok Sabha and state assembly elections to reduce cost and election fatigue. Legal challenges to this requires amendments to the People's Representation of People's Act 1951 and possibly even the Constitution of India. And further, the very challenges that we face regarding one is criminalization of politics, electoral reforms, then misuse of disqualification process or powers, lack of uniformity in High Court rulings. So, regarding decriminalization of politics, although the petitions are pending cases challenging the criminal defamation and laws which have implications for candidates disqualified under Section 8 for defamation-related convictions are still pending, and we found certain other challenges like criminalization of politics despite judicial interventions. Over 43% of members of parliament as of the 2019 statistics have pending criminal cases, and as electoral reforms needed, issues like inner party democracy, state funding of elections, and regulation of digital campaigning are not fully addressed. Then misuse of disqualification powers as such is a challenge. Allegations that disqualification provisions are sometimes used to settle political scores. So this is another important challenge faced by the very electoral process in India. And also it is a kind of challenge to amend the Constitution of India. So also the Representation of the People's Act 1951. And finally we found lack of uniformity in High Court rulings as different High Courts interpret differently in those election petitions filed before them. So it creates inconsistencies in the very law which would regulate the electoral process, corrupt practices, and decriminalization of politics, and also to regulate political parties and to determine the exact disqualification powers there use and the use and extent of application of such disqualification powers. And finally, there is the most important challenge for electoral reforms as soon as possible by amending the Constitution of India, by strengthening the Election Commission of India and the state election commissioners, besides amending the very particular Act Representation of the People's Act 1951 is the urgent need of the hour to conduct free and fair elections in India in regards to House of People or Lok Sabha, the Council of States or the Rajya Sabha, and to all legislative assemblies and legislative councils. Besides that, the very need of the hour is that electoral reforms would definitely have its lasting impact on the elections regarding local self institutions such as the Panchayat Raj system in the rural structure and also in relation to the municipal corporations and metropolitan councils in urban areas. Then the very vibrant democracy that is functioning in India at present would be more stronger and stable, and it would continue everlasting as it is continuing since the year 1947 when we got independence from the British imperialism or colonialism.